Hello everyone, and thank you for tuning in to today's webinar. We have a great presentation lined up for you today, but before we get started, there are just a few general admin points to cover. First and foremost, please use the online question tool to post any questions that you have, and we will share them with our speakers. Second, if you experience any technical difficulties today, please let us know in that same questions tool, and a member of our admin team will be on hand to support you. Today's session is being recorded, and we'll be sharing a copy with you all via email in the coming days. So, without further ado, I'd like to hand over to our speakers to get us started.
Hello, and thank you all for joining. My name is Eric Schweibenz from the Oblon firm, and it is a pleasure to be with you today. I'm the chair of the firm's ITC practice group and also co-chair of the firm's litigation group, and I have been practicing for approximately 23 years, handling U.S. district court cases in front of the International Trade Commission, and generally working on intellectual property related matters. And I'd like to introduce my partner, Chris Ricciuti, at this point.
Thank you, Eric. Good morning, good afternoon, or good evening, depending on where you are. Reiterate Eric's sentiment. I really thank you for joining. I look forward to talking to you today. I'm also a partner in Oblon's litigation group, and for the past 10 years, I've been focusing on district court litigation, federal circuit appeals, and PTAB practice in front of the USPTO.
Great. So next slide. So as an overview today, we'll be talking about various what we see as hot topics and really sort of the cross-section or intersection between the ITC, the International Trade Commission, and how that relates to the practice of inter partes reviews at the U.S. Patent and Trademark Office. Next slide. So this probably will not be unfamiliar to many on the call, but for those it is, we just wanted to go over quickly what the ITC is. It is an independent U.S. federal agency located in Washington, D.C. It's composed of 6 commissioners and 6 administrative law judges. And again, it is an agency, an independent federal agency. And what makes the ITC unique is it's not sort of an agency that handles private disputes between parties, but also involves the U.S. government. And one of those aspects is a third party that is present in most of the ITC cases, but not all. And that office is referred to as the Office of Unfair Import Investigations, or OUII, for the staff. And they may be assigned to act as a third party on behalf of the public interest. Based on our research, I think it's approximately 25% of cases where they may not appear, but there's still an OUII representative in approximately 75% of the cases that are instituted at the ITC. Next slide. In general, the ITC is based on a statutory basis, and that statute is Title 19, Section 1337 of the U.S. Code. Essentially, what it does is it prohibits importation of products that infringe valid U.S. intellectual property rights. Those intellectual property rights can be comprised of patents, which is the predominant number of cases that are brought before the ITC relate to patent infringement disputes, but it can also relate to copyright and trademark disputes, as well as non-statutory rights such as unfair competition. What makes the ITC unique and different, and we'll talk a little bit more about that soon as it relates to district court practice in the United States, is this requirement of an economic or technical prong of domestic industry. This 2-part test makes it very unique and different from the cases that are brought in district court. Next slide. So what we have on this next slide is just some key differences between the International Trade Commission Section 337 practice and district court. And the main takeaways from the slide, as you can tell, is the speed of the forum. The ITC is a very, very quick forum where a trial is taking place in 6 to 9 months after institution, and you receive ultimately a decision from an ALJ or administrative law judge in 9 to 12 months, and ultimately you're getting a final decision or final determination from the ITC in approximately 12 to 16 months. When you contrast that with the district court, you're talking about at least 2 years before you'll get to the same decision point. And it could be several years depending on the jurisdiction that you pick in the United States. So that's one of the takeaways, that the ITC is very fast as compared to district court. Another sort of distinguishing characteristic that we note on the slide is the remedies available at the ITC. There's no money damages. However, the ITC offers what we call exclusion orders or injunctive type relief. This is very powerful because it's a prospective relief and it stops those infringing goods from coming into the United States. On the other hand, the district court offers money damages, which are not available at the ITC. And in light of the eBay decision from the Supreme Court years ago, there's no guarantee in obtaining injunctive relief in district courts. Another interesting characteristic or distinguishing characteristic of the ITC is that there's no jury. All the cases are handled by an administrative law judge and ultimately by the commission itself. We talked about the staff being a third party in many of the cases, and they're there to protect the public interest. And then in the district court, of course, a jury is available upon request, and there is no third party that's involved in the dispute. Lastly, I mentioned it before, but again, this domestic industry requirement is unique to the ITC. And essentially what the requirement is that it requires the complainant and or its licensee must practice the patent and have a U.S. presence. This domestic industry requirement is not required in district court. That's one of the major distinguishing features of the ITC versus district court. Next slide. So now we just want to talk a little bit about the typical timelines between the ITC and also how that compares to other proceedings in the United States that are relevant to our discussion today. Next slide. So as you can see from this slide here, the relative speed of the proceedings. When you're comparing these proceedings, we have the International Trade Commission, again, being the fastest forum in the United States for resolving intellectual property disputes, approximately 12 to 16 months. And you have the inter partes review, or the IPR proceeding, which my partner, Mr. Ricciuti, will talk more about soon, which typically are resolved in about 18 months. And then we have still available in the United States is the ex parte reexamination. You can see that that's going to be slightly slower than the IPR proceeding at the patent office. And then, of course, we talked about district court. So it's very clear from this, depending on which proceedings that you're engaged in, or if there's multiple proceedings, that the ITC proceeding is going to be the focus of the dispute because of its speed and because of its statutory requirements to finish at the earliest time practicable. Next slide. So looking more closely now at the ITC timeline for Section 337 proceeding, what you can see on the left-hand part of the slide is when the complaint is filed. It typically takes 30 days for the ITC to decide on whether it will institute or not the investigation. And then once that occurs, then you have what I would say is the typical activities that occur in any litigation in the United States with fact and expert discovery, but it occurs on obviously a very compressed basis, very quickly, until you move up to the point where you have a trial, which we call an evidentiary hearing in the International Trade Commission, and it's proceeding approximately 9 to 10 months after the notice of investigation has been instituted. Then after the evidentiary hearing, which is heard by the administrative law judge, there's a period of post-trial briefing, post-hearing briefing, which ultimately results in a decision coming from the administrative law judge, which is referred to as the initial determination. And you can see that here referred to as the ID. After that decision comes down, then ultimately you will have the final determination that will come from the commission that's implemented a few months after the initial determination comes down from the administrative law judge. So this timeline shows you the sort of detailed things that happen during an ITC investigation and the timing associated therewith. Next slide. So next we want to talk a little bit about the strategic value of inter partes reviews and how they relate to an underlying ITC proceeding. Next slide. So one of the questions that often is asked is, are IPRs valuable and should they be utilized in connection with an ITC proceeding? And the answer is, from our experience, it's a case-by-case decision, but ultimately, in many cases, the answer is yes. One thing to be aware of is that the requirement to show that the claims are unpatentable in an IPR proceeding is a preponderance of the evidence, whereas the ITC is using the same standard to invalidate patents that they do in district court, which is in a clear and convincing standard. So the burden of proof to show unpatentability or invalidity in an IPR proceeding is lower than the burden that's required in an ITC or district court proceeding, and that's a significant factor that parties need to consider when they're deciding whether to go with an IPR or not as it relates to patents that are asserted in the ITC. Another thing to keep in mind is that the same claim construction standard is utilized in an IPR proceeding as is used in the ITC or district court. We refer to it generally as the Phillips standard, and this is something that used to be different, but now the same claim construction standard is used in all of these proceedings. Another thing to keep in mind is that in the IPR proceeding, there's limited discovery. And so unlike in an ITC case or district court proceeding, there will not be voluminous discovery requests or things of that nature, which would require more money to be spent. So that limited discovery in IPR proceedings is something that's very attractive to petitioners and is something that needs to be considered as well. Perhaps one of the most important things is to consider is the fourth bullet point here, which is with respect to the rejections that are proposed in an IPR proceeding. Oftentimes, the IPRs feature complex obviousness combinations. In other words, that multiple prior art references are being used to show that the claims that are being targeted are unpatentable. And these are very typical in IPR proceedings, whereas if you are presenting very complex obviousness rejections or combinations for purposes of the ITC, this is sometimes something that is not necessarily favored because it's a quick proceeding, and ultimately the PTAB is considered to be an expert on the technical issues relating to obviousness. So sometimes you'll have more success with a more complex argument that you have in an IPR proceeding, whereas the ITC is oftentimes more reticent or reluctant to find invalidity depending on the facts of the case. Another really important consideration from our perspective is to try to give the petitioner or the accused infringer leverage over the patent owner. And that's something the IPR does. Ultimately, by filing the IPR, it gives you immediate settlement leverage because it provides the petitioner a way to get leverage over the patent owner by saying that there's something here that could ultimately threaten the patents. Another thing to consider is that even if an IPR is filed and the ITC proceeding finishes sooner, if the ITC proceeding finishes sooner than the IPR proceeding, there's ultimately a chance after the end of the IPR proceeding, at the end of the ITC proceeding, for those two proceedings to be merged on appeal at the Federal Circuit. And there'll be an overlap in issues that are considered. So it's oftentimes the Federal Circuit will look at those issues together, depending on the timing. So any sort of question of invalidity or unpatentability will be heard at the same time at the Federal Circuit. So it's another reason to consider doing these proceedings at the same time or together with each other. The last bullet point here is very important. Our firm handled a case a few years ago, which was the 337-1052 investigation, in which we were successful in challenging the constitutional standing of the complainant in a case, and we're successful in getting the case terminated. So if there's any way as an accused infringer that you can get the case delayed or need to force the complainant to refile the ITC investigation, that could be helpful, because ultimately what you're looking at is trying to get the IPR decision to occur before the conclusion of the ITC proceeding. And if that can happen, that can affect whether or not the ITC exclusion order will be put in force or whether it will be suspended. So this question of doing IPRs is a very important one that needs to be made on a case-by-case basis, but ultimately you want to look at each case individually to determine whether it makes sense to do an IPR or not. Next slide. Whether you obtain a stay of an ITC proceeding in view of an IPR is something that has been considered and frankly is not really possible. There's been several attempts that parties have made, and the ITC looks at various factors to determine whether or not they will stay the proceedings in view of an IPR that's been filed. The ITC has very specific criteria of items that they look at. And we've given an example here as the 983 investigation, where a motion to stay was denied, despite there being a favorable timeline between the IPR and the ITC proceeding. So the IPRs, as indicated here, were instituted on a portion of the claims of the three patents in suit. And although the ITC must finish the investigation at the earliest practicable time by statute, the parties still sought to stay the ITC proceeding. And although when the ITC considered its 5 factors, it ultimately found that every factor favored denying the stay. So the chances of getting an ITC proceeding stayed are very low. And in fact, the only example that we're aware of is in the 1024 investigation noted here, where an ITC investigation was stayed based on a parallel IPR proceeding. However, the important factor in that case is because the parties agreed. There was an unopposed motion to stay in view of the Federal Circuit review of an IPR final written decision. So what's really important, and the takeaway from this slide, is that the ITC is essentially immune from an IPR attack in terms of staying the proceeding, and it's something that needs to be considered, is that you will probably not be able to stop the ITC proceeding from moving forward. But ultimately, we still think that filing IPRs is a good idea, again, depending on the facts of the case. Next slide. So now talking a little bit more about the timeline and looking at the different examples of when an IPR proceeding, whether it occurs or whether the final written decision from an IPR proceeding comes before or after the ITC is concluded with their investigation. We first look at this 939 investigation at the top of the slide, and you see an example here where the Patent Office found certain claims of an asserted patent unpatentable, and then a few months later, the ITC had issued remedial orders, but suspended enforcement of the 934 claims previously found unpatentable by the PTAB. In that case, the enforcement of the ITC's remedial order as to the 934 patent remained suspended pending the Federal Circuit review of the PTAB's final written decision. So what it really comes down to is when the PTAB decision occurs versus when the ITC's final determination occurs. And we have here with a certain magnetic tape cartridges case in the 1058 matter, the ITC suspended enforcement of the exclusion orders as to the asserted claim that the PTAB had previously found unpatentable that issued after the ALJ's initial determination, but before the ITC's final determination in the investigation. And then more recently, in the 1167 investigation, we have the same set of facts, essentially where the ITC suspended a limited exclusion order and cease and desist order pending the Federal Circuit appeal of an IPR final written decision. Again, the question is about timing. So if the final written decision from the PTAB issues before the ITC's final determination, then the exclusion order is not going to be enforced, will be suspended. But if the final written decision from the PTAB comes after the ITC issues its remedial orders, it will go forward in terms of the enforcement of the ITC's exclusion order. So the timing of these proceedings in terms of how they move forward is critical. And if it's possible to get the timeline for the IPR ahead of the timeline for the ITC, you should take advantage of that situation. It's a very important issue right now in the ITC and IPR proceedings, and it should be looked at in each case on a case-by-case basis. Next slide. So at this point, I will turn it over to my partner, Christopher Ricciuti, who's going to talk a little bit more about IPR statistics as it relates to ITC proceedings.
Thanks, Eric. And while I still have you on the line here, one question was just, you had mentioned standing as a potential way to slow down the ITC proceeding and then hopefully get the IPR out in front of the ITC. Is standing the only way, or are there any other potential ways to try to slow down that ITC train?
Yes, that was the one that we used in the 1052 case, but there are other examples of how to slow down an ITC case, and that sometimes will just happen in the nature of an ITC case where there may be delays in institution or there may be other factors where the ITC is asking for supplemental documents to be filed at the beginning of the case. So, and with all the restrictions that have come forward with COVID, there's been delays also in the ITC proceedings. So sometimes that's not necessarily forced by an accused infringement, but by the nature of sort of the things that are happening in the world. That's another way that cases have been slowed down. But other than standing, there are other procedural mechanisms that can happen if perhaps the wrong parties are chosen in the ITC case, or other things that may cause a delay in the proceeding. That was just one example of ways to slow down. So yeah, there are other ways that the ITC case can be slowed down or stopped, but the standing was the one that we picked as an example because we had used that in the 1052 investigation.
Perfect, thanks, Eric. So now we'll switch gears a bit to talk about some recent IPR statistics, and then we'll kind of circle back and tie it into the ITC in a little bit here. So next slide, please. So on this slide, you have the institution rates from fiscal year 17 to 21, both by petition and by patent. And on the left, you see in fiscal year 2021, the institution rate for petitioners was at 59%. When you go to the right, and when you look at it on a per patent basis, it goes up a little bit, and it's at 65%. The reason for that is typically multiple parties may challenge the same patent with different petitions, or there could be circumstances where it's appropriate for an individual petitioner to use multiple petitions against the patent. And so that typically ticks the institution rate by patent up a little bit more than on a petition basis. But on a petition basis, what we've seen kind of year in, year out for the past 5, 6, 7 years is that institution is always hovering around 60%. Next slide, please. This slide looks at how does this break down by technology. We have 2020 on the left and then 2021 on the right. And if you look at where the bulk of the IPRs are being filed, it's in the electrical computer space, in the mechanical arts, and in the business method arts. And those typically hover around the historical institution average of 60%. Depending on the year, the unpredictable arts, particularly the chemical space, is lower than that 60% rate. And you'll see here in brown, design patents are presented. The thing with design patents is they're so infrequently challenged before the PTAB via IPR that it's really hard to really glean anything out of the numbers. You can see in 2020, it was 14% institution rate, but all the way up to 80% institution in 2021 because only 5 IPRs against design patents were challenged. Next slide, please. And so here's another slide where rather than looking at institutions, let's look more at case outcomes. The Patent Office puts this chart together every single year, and it's a little bit small, but I'll read it for you. What they ultimately say is when you look at case outcomes, 16% of challenge claims and 38% of instituted claims were found unpatentable by a preponderance of the evidence in fiscal year 21. But that's looking at all of the cases overall, including settlements, procedural denials, and other reasons that a case may go away before you get to a final written decision. So what do these numbers actually mean on a case-by-case basis if you get to the final written decision? And that takes us to the next slide. And so here, what you can see is that in fiscal year 2021, there were 340 IPR cases that proceeded to a final written decision. And in 265 of those, or in 78% of the cases that proceeded to a final written decision, at least one claim of that patent was canceled. This number is down a little bit more, a little bit from 2020, where the number was 84%. But again, just like institution over the past 6 to 7 years has hovered right around 60%, this historical, and I guess for lack of a better word, claim kill rate hovers around 80%. So if you are a patent owner and if your the IPR that is filed against your patent has been instituted, historically, there's about an 80% chance that you're going to lose at least one claim. So from a patent owner's perspective, that preliminary response where you have a chance to avoid institution becomes very important when you're just looking at the numbers and attempting to keep your claims alive, keep the case alive, and stay out of the IPR process. Next slide, please. So the next thing that we'll talk about is fintive. And so we can move on to the next slide, and discretionary denials under the fintive standard. So for those who follow the IPR space or have thought about filing an IPR in the past year or two, or did file an IPR in the past year or two, you've probably heard of the Apple v. Fintive case or its predecessor, NHK Spring. And what these cases do is they set up the groundwork and the rubric really to guide the board's analysis under Section 314 regarding whether they're going to institute an IPR in view of a related litigation in the district court or at the ITC. And so the PTAB will look at 6 things. They look at whether the court has granted a stay or is likely to grant a stay. And they look at who's going to resolve the dispute first. Is the validity question going to get addressed more quickly in the parallel district court or ITC case, or will the PTAB proceed to a final written decision prior to that parallel proceeding? They look in the investment in the parallel proceeding, which ultimately comes down to how quickly did you get the IPR on file before substantial resources were invested in that parallel proceeding. Is there an overlap in issues between the two venues? Are the petitioner and the defendant or the respondent, are they the same or different parties? And then are there any other circumstances that the board should consider, including potentially the strong merits of the IPR decision before they ultimately reach a conclusion under Section 314 here? Next slide, please. And when you look at the numbers of how often Section 314 has been used over the past few years, there really was an explosion of use of 314 in 2019 and 2020. If you look at the chart on the left, you can see in 2018, there were 118 cases that were denied institution for procedural reasons. Without even really addressing the merits. This number jumps up to 162 in 2019, and then all the way up to 228 in 2020. And then when you go to the graph on the right and try to figure out what type of issues is the board analyzing for their discretionary denial practices, the vast majority in 2019 and 2020 were 314A, which is typically fintive. You can see in 2019, 84 cases were dismissed procedurally under 314A, and then in 2020, 167 cases were dismissed under 314A, and the bulk of those dismissals are again going to be fintive. Thus far in 2021, there have been 77 fintive denials. And so if we move to the next slide, I think the question becomes, is use of fintive slowing, and why may this be the case? And the answer is yes, it does appear to be slowing, which if you're a petitioner is a good thing. As a patent owner, you're probably not as happy about it. If you look at October 2020 to March 2021, 38% of cases where there was a fintive analysis were denied. But then when you look at April 2021 to September of this year, it drops down to 19% of cases where there was a fintive argument and a fintive analysis there was a denial in those cases. And so why the drop? And I think there are two things that are really causing this. The first is that that second factor, the speed of trial. Who is going to get to trial first? Is it going to be the district court or the ITC, or is it going to be the PTAB? And at least with respect to district court proceedings, I think what the PTAB is realizing is that these trial dates often slip. You may have an initial scheduling order that sets a very aggressive trial date, but for scheduling extensions or a variety of other circumstances, that date can slip. And so I think the PTAB is putting less stock into that initially scheduled trial date and not weighing that factor as dispositive as they once were in the beginning of the FinTIV practice. The second thing that's happening here that we'll talk about more later, which is I think critically important for when you have a co-pending ITC case, is a stipulation. And it's a stipulation that's going to tell the PTAB that if you institute in my parallel proceeding, I won't raise the same arguments that I'm raising here. Parties have gotten a lot more comfortable with those types of stipulations, and I think that really has muted to a certain degree FinTIV and how applicable it is across the board generally. Next slide, please. So we're here to talk specifically about the ITC. So how does this translate when you are trying to get an IPR instituted, but you have a parallel ITC proceeding? And if you look at the circle, and this was a study done by the PTAB Bar Association earlier this year in August, and they looked at, well, the sampling of cases before 2020 where there were arguments about making some sort of discretionary denial. And you can see here the vast majority of cases in the orange, 36 of them, they were instituted notwithstanding the fact that you were in an ITC case that was going to move very quickly and would conclude prior to the PTAB rendering its decision. Only one was denied. Now, if we look at after October 2020, which is when FinTIV became precedential, the analysis flipped. And you actually have 32 cases where, because the ITC moves so quickly, the PTAB said they're going to address validity first or invalidity first, and so we're not going to wade into the dispute there. And there were only 4 cases where, notwithstanding a FinTIV argument, the IPR was still instituted and still moved forward. So I think this is very telling if you're in the ITC. And if you move to the next slide, please. The big takeaway here as a respondent in the ITC, as a potential petitioner before the PTAB, is that you have to move very quickly. I think, unfortunately, as things stand today, while FinTIV is still technically in play, probably within 1 to 3 months after the ITC case is instituted, you want to get that IPR on file. What else should you do? We talked about stipulations, and the main one here that I will refer to is called a SOTERA stipulation. And this comes from IPR 2020-010, IPR 2020-01019. And what you do when you file a SOTERA stipulation, which is going to get filed in the co-pending proceeding, so you'd file it in the ITC, the petitioner tells the ITC that they're going to drop from the action any invalidity argument or ground that they raised or reasonably could have raised in the IPR if the IPR is instituted. So what you're doing is you're time shifting estoppel. You're essentially agreeing to estoppel much sooner in the case than you otherwise would have. And it's thereby reducing the overlap and issues between the proceedings. The PTAB knows that if they go forward with this IPR, they are going to decide the validity issue based on patents and printed publications, And if there is a validity issue in the ITC, that'll likely be based on prior use or prior sales or something else that the IPR petitioner just couldn't technically bring in the case before the PTAB. And that has gone a very long way. Petitioners are getting very comfortable with those stipulations, and it really is appeasing the PTAB to institute these cases, notwithstanding aggressive trial dates. And I think interestingly, the four cases on the prior slide where there was institution, notwithstanding an ITC case that moves very quickly and notwithstanding a fintive argument, they all had at least a cetera stipulation in the case. And one such example that if you're interested in the co-pending ITC matter is certain tobacco heating articles 337 TA 1199. This is a case between RAI and Philip Morris, and Philip Morris was still able to get its IPRs instituted despite the speed of the ITC. There's another type of stipulation out there that you should be aware of. It's a sand revolution stipulation, and this stems from IPR 2019-01393. This is a little bit weaker than Sotera, and what the petitioner says here is that they agree to drop any invalidity ground that they raised if the IPR, in the IPR from the parallel proceeding, if that IPR is instituted, but they don't go so far as to say we will also drop anything that we reasonably could have raised. And in a slide or two, we'll talk about when that might be appropriate to use a sand revolution stipulation as opposed to a Sotera stipulation. The other thing you want to do as a petitioner, if you're dealing with a very quick ITC case, is you want to try to highlight any strong merits or unique facts that you have in the case. Maybe there's something that is very germane in the file history that the Patent Office would be very appropriate to look at and to judge, as opposed to certainly a jury at the district court or maybe even an ALJ sitting at the ITC. They're obviously very well equipped to look at those file history type arguments as well. There could also be other relevant findings from other tribunals, maybe something from the European Patent Office, maybe from a prior case in the US. And these kind of unique circumstances sometimes can help nudge your case towards institution rather than denial when we're talking about fintive analysis. And the last thing that I wanted to mention is there have been cases where petitioners challenge more claims, than what has been asserted at the ITC or in the parallel district court proceeding. And in those cases, there are certain panels that will view that as a unique circumstance that might be able to help you get around fintive. Next slide. So on the flip side, if you're a patent owner and you want to get the case denied, whether it be on the merits or procedurally, particularly if you're in the ITC, I think you want to make a splash and limit that pre-investigation warning. And if you've asserted many claims and many patents against the respondent, it's going to be a Herculean effort for them within a few short months to get their hands around a bunch of patents that they haven't considered before, infringement analyses that they're just looking at, get the prior art searching done, analyzed, and then to get petitions on file in such a short time period may make it practically impossible to go down the IPR path if there are just too many patents and too many claims that are involved. To the extent there is delay on behalf of the petitioner, you certainly want to highlight that as a patent owner, and you want to show that because the petitioner, it took them 4 or 5 months to get the IPR on file. In the ITC case, here are all the substantial resources and undertakings that have occurred in those 4 to 5 months. Of course, you're going to highlight the fact that the ITC moves quicker than the PTAB. And last, but certainly not least, if there are weak positions in the IPR petition, you absolutely want to highlight that as a patent owner. Next slide, please. And so here's kind of not quite a green, yellow, red analysis, but a green, yellow, orange analysis for general timing considerations for IPRs when you're outside of the ITC. Again, if you're in the ITC as things currently stand, you're really looking at kind of 1 to 3 month window to get your IPR on file. But when you're outside of the ITC, if you're within that 1 to 3 month window, then I think you're in the green light territory. You probably don't even have to worry about a stipulation because you got that IPR on file very quickly. And the timeline between the two proceedings won't be all that far off, and FinTIV may not be a very big concern. If you are getting your IPR on file 3 to 6 months after service of a complaint, here's your yellow territory where you might need that sand revolution stipulation where you at least tell the PTAB that if the IPR is going to be instituted, I will drop from the co-pending case everything that I've raised in the IPR. And then if you're outside of 6 months and you're getting the IPR on file more than 6 months after being served with a complaint, here's where I think you're in the orange territory, and you're likely looking at that SOTERA stipulation where you're telling the PTAB and the district court that if the IPR is instituted, you will drop any ground that you raised or reasonably could have raised. And in an ideal circumstance, you're also in a slow court or a court where maybe there has been some pre-answer motion practice that has delayed things, and you still have a good longer district court timeline than the approximate 18-month timeline that Eric had mentioned at the beginning of the case for your typical IPR proceeding. Next slide. And so finally, we can skip ahead to the slide after this one. We just want to end here talking about the Restoring America Invents Act that Senator Leahy and Senator Cornyn have proposed. I believe it was September 29th of 2021. I'll quickly run through a number of key proposals in here, almost all of which are aimed at the PTAB. But before I get there, one interesting thing to note is Senator Leahy, who has been an active U.S. Senator for 40 years and has been head of the IP subcommittee for a number of years, very, very interested and actively involved in the AIA, in the patent office, and in IP policy in general. He just announced his retirement yesterday. And so this may ultimately kind of turn the IP issues before the Senate and before senators who just aren't as interested in IP in the patent world as Senator Leahy. And so maybe some of these proposals in this Restoring the America Invents Act are not going to gain as much traction and may not make it in if Senator Leahy is not able to get things done before he retires. And so with that, again, I just want to quickly kind of go over a number of the key things that this bill proposes. First and foremost, and I think very close to what we've just been talking about, the bill proposes to remove the PTAB's authority to deny institution based upon FinTIV and parallel litigation proceedings, whether it's a district court or an ITC. And effectively, they want to limit discretion to 325D, which is an instance where a patent owner argues that, hey, the same thing has already been argued during prosecution or something very similar to it, so don't waste your time here. Obviously, in view of the stats that we looked at earlier with how prevalent FinTIV was, at least in 2019 and 2020, even though it's slowing now, it's still being used. And so if FinTIV is taken off the table, that is certainly a pro-challenger position, and it's a good tool the patent owners had that is going to go away. The bill proposes to codify the Supreme Court's Arthrex decision, essentially put into the statute director review process that is already being implemented in an interim fashion. The bill will change the law so that the U.S. government can now file IPRs and PGRs. It will expand the scope of the grounds that you can include in an IPR to include obviousness type double patenting and patent owner admissions. On a procedural note, the 1-year filing window is going to be restarted after there's a dismissal without prejudice. As things exist today, if you have a district court proceeding that is dismissed without prejudice, the clock still runs for your 1-year time bar. And so this part of the bill would change that. And the bill also notes that new or amended claims that are issued after a lawsuit is filed are going to get a new 1-year filing window. A very, I think, drastic proposal that I think is going to face a tremendous amount of pushback, and I would be very surprised if it makes it into law, is the statute would be rewritten in a way that when you analyze stays, it's going to encourage them. And if the district court does not grant a stay, then there's immediate interlocutory review, again, even further encouraging a district court stay in view of PTAB litigation and the PTAB proceeding. This would not apply as currently written to the ITC, though. It would just be to the district court proceedings. Next slide. A minor point here, as things currently exist, there's a difference in estoppel for an original petitioner and a joinder petitioner, and the new proposed law would make that scope of estoppel the same. The other change is estoppel would only apply after all appeals have been exhausted, rather than after a final written decision as things currently stand today. And as part of the appellate practice, if you're a petitioner and you're ultimately found to lack standing before the federal circuit during your appeal, there will not be any estoppel. Right now, there's certain PTO rule-based estoppel for when patent owners can bring arguments that they may have lost on, or try to get a claim scope that is similar to a claim that they've lost on during an IPR. That rule-based estoppel is going to get codified in the new proposed rules. The rules propose to essentially overturn the Aqua Products decision, and rather than it being the petitioner's burden to show the unpatentability of amended claims, it is going to be the patent owner's burden to prove the patentability of its proposed amended claims. And the law would provide a mechanism for the PTAB to actually conduct an examination of the proposed amended claims. IPR certificates will issue within 60 days of a proceeding's conclusion, which would be after final written decision if no appeals are filed, or ultimately after a mandate issues from the Federal Circuit or Supreme Court. They're aiming for a 120-day time limit for rehearings before the PTAB. I think that's already kind of an internal guidepost the PTAB uses, but at present, there is no actual deadline for the PTAB to issue a rehearing decision. And then finally, the proposed bill would expand appellate standing so that if a petitioner reasonably expects that another person will assert estoppel against it as a result of final written decision, that petitioner will have appellate standing. So essentially, the law makes it a little bit easier for petitioners who have not yet been sued and they proactively file an IPR. The law makes it easier for these petitioners to go ahead and appeal their case and not have to worry about a lack of standing. So we can go to the next slide. And so with that, that's all that we had planned for the slides to go over in our talk today. I don't know if maybe we have a little bit of time here, if there are any questions that may have come up that we could go over.
Yeah, we do, Chris. Well, so one question that has been raised is the question with respect to why is it that it's easier to raise the more complex obviousness combinations in the sort of the PTAB context versus the ITC, and I think we'll direct that to you and sort of why is it traditionally easier to raise those more complex obviousness combinations in that form versus the ITC, and I can handle part of that if you want, but I think it's probably more directed to your space.
Yeah, absolutely, and feel free to chime in, Merrick. But the PTAB itself is an obviousness court. And I had actually just pulled these statistics earlier in the summer, and I don't have them off the top of my head, but it is the vast majority of cases. I mean, in the 90% of cases, there is an obviousness question involved. There's a very small minority, I believe it's about 4 or 5% of cases historically since IPRs have been instituted, where the petition only relies on anticipation. And so this is what the PTAB judges do day in and day out, is they analyze obviousness, and they're very comfortable taking 2 or 3 references and following the obviousness combination and making the combination and finding claims unpatentable when you have a more complicated obviousness argument, you might say. And that's the only thing that they are deciding. That's the only thing that the experts are there to opine on. And I think the ITC that is just more similar to a district court. In view of all of the other issues, the story of the patent and the invention that gets told, and the very deep factual development that you have there, if you don't have, a very strong anticipation argument or a very strong obviousness argument, I think just it looks weaker, I think, just given the difference between the two forums. But please, if you have anything to add, Eric, go ahead.
Yeah, and I think you make the points you make, I would totally agree with, and it goes ultimately to the burden of proof issue too. You're looking at a situation where you not only have the more complex obvious combinations in the PTAB, but they have a lower burden of proof to overcome there with the preponderance of the evidence standard. And given that you have the clear and convincing standard in the ITC like you have in the district court, that sometimes is going to let you gain more traction in the PTAB proceeding as well.
Agreed.
Yeah. And another question that has come up is sort of how has the PTAB practice changed with the COVID-19? And I don't know whether you had any comments on that.
So I think the biggest change, Eric, is that depositions, by and large, and maybe things are changing a little bit as we sit today, but for the past year and a half, they've been conducted remotely, along with oral arguments have been conducted remotely. But the PTAB has already been a very remote savvy jurisdiction. Even prior to COVID, it would be very typical that although you would have your oral argument on the 9th floor of the USPTO, either 1 or 2 of those judges would already be at a remote office and wouldn't be there live in person. And so I think the members of the PTAB bar and practitioners who were arguing before the PTAB were very comfortable with remote presentations. They were effectively doing it already. And so the switch to fully remote for COVID, I don't believe was a very large switch, but certainly the remote depositions, which were not occurring with much frequency prior to COVID, that was certainly a big change. And we'll see if practitioners enjoy that, not having to travel, and if even once hopefully COVID goes away and calms down and we have our new normal, if that practice will stick around, or if everybody will be back in conference rooms again.
Yeah, it's a great point. And in fact, I sort of participated in my first in-person argument at the Federal Circuit here a few weeks ago, and so that was odd to sort of be back in the swing of things again. But I think you're right. I think the PTAB has sort of set itself up to be more accessible via remote, and it's probably was less impacted by COVID-19 than, say, the district courts, where you're dealing with juries and things of that nature, which obviously made things much more complicated. Another question that came through here is sort of what do we see in terms of the outlook for the future as it relates to ITC cases, and it's a great question, because ultimately We've said it for years at our firm, and I think we see the ITC becoming increasingly popular for many of the reasons that we said at the beginning here, but the main reason being that the speed of the ITC investigation being something that really sort of drives parties to that forum if they have the right case, particularly for emerging technologies where sort of the life of those technologies may be quite small, so you're worried about protecting that market share. But also, I think this is a practical matter, and this sort of relates to something that you said, Chris, which is that sort of the immunity of the ITC proceeding to the IPR attack. And that's something that I think that will continue to attract litigants to the ITC, is given how fast the ITC proceeding is, that sometimes that seems like a preferred forum because you may not get your case slowed down in view of the IPR choice that's made by some of the accused infringers or petitioners. I don't know if you would agree with that, but I think that's a pretty important point too for why more parties may consider the ITC going forward than they haven't in the past.
I completely agree, Eric. And along that same line, I talked about that one proposal where in the Restoring America Invents Act bill, they are trying to encourage district court stays in view of IPR, and that provision would not apply to the ITC. Now, I had mentioned I don't think that proposal is really going to gain much traction and go through, but if it did, or if something like that happened in the future, and it only pertained to the district court and not the ITC, that would be a huge reason for more patent owners to look to the ITC so that they know that their case is going to move forward, it's going to move quickly, even if an IPR is filed.
Yes, and we put all these thoughts out here today, and I guess just I wanted to end on a note that it's always sort of a case-by-case analysis that you're doing here, and it's not one size fits all. You're not going to always file an IPR if you have an ITC presiding, and you're not always not going to do it. It's just something that you have to look at in each case, depending on the technology, depending on when the ITC case is filed, depending on the number of patents and claims that are asserted. You're looking at this on a case-by-case basis and then making that determination. So it's important for everybody to take away that these are just factors that you think about. And what we wanted to do is really try to highlight what we see are the sort of the crossroads or intersections between what are two very sort of different but and very complicated proceedings, and sort of how they come together or not in certain cases. And it's, from our perspective, a sort of something that hasn't been looked at as closely as people sort of comparing the ITC to district court. But we think now that comparing ITC with the IPRs is something that's going to become more prevalent going forward. It's really important to look at this, together, and how those proceedings can intersect and be used together to get results on either side. So it's really, we think it's an emerging issue, one that's important, and it's going to become more prevalent as we move forward.
I completely agree, Eric. And
okay,
so
with that, I think we might have reached the end. But again, if you have if there's another question out there, I'm happy to answer it.
No, I was just looking through. I think we've answered all the questions that were raised. And I would just like to say thank you for everyone that's joined, and we appreciate your time today and look forward to talking to you again in the future.
Yep, I echo that. Thank you, everybody.
Thanks. Bye-bye.